a significant ruling, the Madhya Pradesh High Court has held Section 10 of the Madhya Pradesh Freedom of Religion Act of 2021, which is the state's anti-conversion law that requires a person desiring to convert his or her religion to give a declaration in this regard to the District Magistrate to be prima facie unconstitutional. Accordingly, a bench comprising Justice Sujay Paul and Justice Prakash Chandra Gupta restrained the state government from taking any coercive action against any person who contravenes Section 10 of the Madhya Pradesh Freedom of Religion Act of 2021 and has also barred state authorities from prosecuting adult citizens who have married out of their choice and not after forceful conversion. To provide a bit of context for all of you, Section 10 of the Madhya Pradesh Freedom of Religion Act of 2021 stipulates that if someone wishes to convert their religion, they need to submit a declaration to the District Magistrate 60 days in advance, stating that they are doing so not under any force, coercion, undue influence or allurement. For violation of this provision, a person can be punished with a jail term of 3 to 5 years and also a fine of at least Rs 50,000. The Madhya Pradesh Freedom of Religion Act of 2021, which was notified last year, also has provisions for a prison term up to 10 years for anyone found guilty of using marriage to force someone to change their religion. The 2021 Act replaced the Freedom of Religion Bill, which was passed by the State Assembly back in March 2021. Essentially, the Madhya Pradesh High Court was adjudicating upon a batch of petitions challenging the constitutional validity of the 2021 Act. The petitioners had urged the court to restrain the government from prosecuting individuals under the law till the case was being heard. During the hearing, the petitioners had argued before the High Court that the law gave unbridled and arbitrary powers to authorities to prosecute citizens. They also contended that the legislation interferes with the fundamental rights of citizens to practice any religion and marry a person of their choice irrespective of the religion of their spouse, stressing that every citizen has a valuable right not to disclose his or her belief. The petitioners strongly submitted before the court that a citizen is under no obligation either to disclose his own religion or his intention to switch over to another religion. On the other hand, however, the government argued that any interim relief by the court would amount to a final verdict on the matter. It also urged the court to uphold the constitutional validity of the legislation. At the very outset, the High Court took into account Supreme Court's judgments in the cases of Lata Singh versus State of Uttar Pradesh and others, and Lakshmibai Chandraragi and another versus State of Karnataka and others, to emphasize that marriage, sexual orientation and choice in relation to these aspects are in the realm of right to privacy and has a direct relation with the dignity of the individual. The High Court further underscored that the constitutional right to freedom of religion under Article 25 has implicit within it the ability to choose a faith and the freedom to express or not to express those choices to the world. Consequently, the court came to the conclusion that a strong prima facie case had been made out by the petitioners for the grant of interim protection in relation to the marriage of two adult citizens for violation of Section 10 of the impugned legislation, therefore directing the state authorities to not prosecute adult citizens if they solemnize the marriage out of their own volition and not under any coercive action. The court ordered the state government to file its para-wise counter affidavit within a period of 3 weeks. In a similar development, the Gujarat High Court had last year stayed the operation of certain provisions of the Gujarat Freedom of Religion Amendment Act of 2021. The Gujarat High Court had prima facie observed that the law interferes with the intricacies of marriage, including the right to the choice of an individual, thereby infringing Article 21 of the Constitution of India. A division bench of the Gujarat High Court comprising the then Chief Justice Vikram Nath and Justice Biren Vaishnav had observed that the provisions of the law commonly known as the Love Jihad law put parties who have validly entered into interfaith marriages in great jeopardy. Thank you. I'm Aratra Bhomik for LiveLaw. Keep watching LiveLaw for more such updates.